it.
Yes.
I was thinking like trying to figure out like how many calories you burn in a day exercising, like not when you were like training for the Ironman or anything like that, just like on a normal training day. What do you think?
Okay. Do you know? I know how many I burn in a normal day.
Yeah, how much?
Usually around 700.
Okay, I figured out a good way for you to burn 1,000 calories.
Okay.
All you have to do is leave the pizza in the oven. Come on, you get it?
I get
Oh,
it.
man.
You know, you guys are supposed to submit him jokes so that they get better. Okay. I'm recording it.
It's good.
It's great. I'm still admitting people.
All right, you ready to get started?
Yeah, people are still jumping on, but I can keep admitting and you can go.
I'm going to do a test one next time. So.
All right, admit all. We got 58 participants.
So while we're waiting, Marley, you know how I have a bagel every morning? So my
What was
bagel
that?
this morning
Yeah.
tried to run away, so I put locks on it.
Cut his mic.
No.
Cut his mic.
Unfortunately, he's already used this one on me, so now he's reusing jokes, guys.
Oh, they're not even new ones.
No,
Well,
but
that was a good one. I like that one.
Do not encourage him, Rochelle. Oh. All right, Paul. I think, we got a chat going on here.
seriously,
Oh, that's Julie. All right, I think everybody's in.
hold on. I want to take a vote. Like, who would rather hear jokes as opposed to Janelle talking to Marley to try and figure out how to admit to Come on.
Ha, ha,
Here's your-
ha. All right, we're good, Paul. Start us off.
Okay. Sorry we're starting a little late. I like to start these on time. We're going to try and keep this to under an hour for you. There's just a lot that's going on in the city of Philadelphia, so I want to make sure that you guys are all up to date with the latest. So the first thing that's happening is amendments to the
Hold on, Paul, hold on one second. Everybody, I'm going to mute everybody because we're getting a lot of noise. Paul, you're going to have to unmute yourself, so hold on a second. Okay, go ahead, Paul, unmute yourself. Okay, there we go. That's better. Go ahead.
Okay. Actually, before we get started, quick disclaimer. This is being recorded, so if you don't have time to stay on for the entire time or you have other people in your staff that you want to have listen to it, it will be on our website. Just so you know, there's no expectation of privacy because it's being recorded. So if that's a problem with you, you can get off the call now. Just a legal disclaimer. The other thing is that the advice that we give you is only good for today or this hour. Things change so rapidly that if you go back to look at this, today is December the 8th. This is only good for December the 8th. So if you're
Until noon.
if you're looking at it after that, this may not be valid. Okay. I think that's it for the disclaimers.
If you have anything you need to ask, comment, just throw it in the chat. If you'd like to be unmuted, put it in the chat. I'll unmute you, or just throw the question in there and I'll ask it out. I got to keep everybody on mute or else we get a lot of noise and feedback, and we do record it for anybody who can't be on. So.
Okay. The Emergency Housing Protection Act was passed over the summer, the original act. It said that for a COVID-19 financial hardship, which was defined as a financial hardship between the period of March the 1st and August the 31st. certain protections were provided to tenants. You should all pretty much know about that. We've done seminars in the past about that. I'm not going to go into that in detail today.
If you don't know about it, there is a link on our website from our last seminar that explains everything.
Okay. It covered basically late charges, saying you couldn't charge late charges if they had a COVID financial hardship between that period of time. You had to send out a hardship repayment notice before you could go ahead and file for eviction, and you had to apply for the diversionary program. Okay, that was basically the three main things in the act. Okay, the amendments to the act, which just got passed, and I noticed there was a typo in our email that went out. It said it was passed on December the 8th. It wasn't passed today. It was actually November the 8th. That was my mistake. Apologize. It went into effect as of November the 8th. The actual effective date doesn't really matter because it made everything retroactive. And it made it retroactive to the period from the end of August, the end of when the original act went and was enacted, till the end of December. So now the COVID-19 financial hardship period goes from March the 1st through December the 31st. Okay, that's very important. So if the tenant has a COVID-19 financial hardship during that period of time, then you can't file for eviction against them until you do certain things. So the first thing that you need to do is you need to send out a hardship repayment notice. That gives the tenants 30 days to write back to you and tell you that they want to enter into a hardship repayment plan. That plan means that they have the right to repay the back money over a 9-month period. Now, this gets a little tricky with the amendments because the amendments were amended. Okay, so what happened was that the initial period was from March the 1st through August the 31st. If they had any money that was owed during that period of time, you would have to reach a payment agreement with them for them to have the opportunity to pay that money back over a 9-month period. That period now goes through December the 31st. So that if they have any rent that they owe you between March the 1st and December the 31st, all that money can be put into a payment plan that they start paying back over a 9-month period. They have to stay current as of January the 1st. Under the old law, it used to be they had to stay current as of September the 1st. Now with the amendment, they have to stay current as of January the 1st.
Well, let me interject here and ask a quick question just to play devil's advocate a little bit. What happens if you've entered into a hardship repayment notice where they had to stay current starting September 1?
Did you put it in the chat? I didn't see it down there.
I am the chat, okay?
I'm sorry, say that again.
So let's say, since it was all retroactive and you're saying that they don't have to stay current till January 1, what happens if we already entered into a hardship repayment agreement with them and they had to stay current starting September 1 or October 1, say, for sake of argument?
Yeah, that's a great question. And this is where the amendment to the amendment came in. And this is what we were able to change.
I was throwing you a softball.
Okay, so what happened was this was a concern that we had because people had already entered into repayment agreements and then they violated that agreement. The way the amendment was originally written, they could enter into a new agreement. The old agreement didn't matter and include all the additional money that was owed. Okay, that was changed, however, to say that if they reached an old agreement, that old agreement is in force and they have to live up to that old agreement.
So good news, score one for the landlords for once.
Yeah, many victories around these days. But essentially what's happening now is that whatever money is owed through December, that's going to be put into a payment plan. Okay. Under the old law, not only did you have to send a hardship repayment notice and wait 30 days, but then you had to file with the diversionary program before you could file for eviction. Diversionary program is just a fancy word for mediation. You had to go to mediation before you can file a landlord and tenant complaint. Under the new amendments, they specifically said, and this was really ambiguous, so we wanted clarification on it, and we were able to get that. Under the new amendments, you can now send the hardship repayment notice, and then immediately thereafter, file for the diversionary program. You don't have to wait the 30 days. What that means is that the two 30-day periods are now running concurrently rather than consecutively. So that it's now just one 30-day period that you have to wait before you can file the complaint. I mean, that was a big problem that we had with the diversionary program and the amendments to the bill, is that it was now putting another 30-day extension on you being able to file and get into court. As it is, you're not getting into court until, what are we up to, guys? April, if you file now. So if somebody,
Yes,
Amanda, what'd you say? Yeah, April?
yes.
Okay, thanks, hon.
okay, so if you think about it, if you have a tenant that hasn't paid December's rent, you first have to send the hardship repayment notice. You then have to file for diversion, mediation. You have to wait 30 days. So you're not filing until January. There's going to be an onslaught of filings in January because of a lot of time periods, and moratoriums are ending as of that period of time. So if you're filing in January, if you're filing now and you're not getting a hearing date until April, if you're filing in January, you're not getting a hearing until God only knows when.
Real
So-
quick before you move on, Melissa Small asks, if there is a prior payment plan agreement, then no need to send another notice. No, if you already sent the original hardship repayment notice and you entered into a hardship repayment plan, a hardship repayment agreement, you don't have to send another one. That's what the new amendments state.
Correct.
Okay, that's it.
Okay, so our recommendation to everybody is send out that hardship repayment notice immediately. They haven't paid, get that notice out and file for the diversionary program. Now, the way the diversionary program works is that you apply with the diversionary program for a mediation date. If they can give you a date within 30 days, then you have to go to that mediation within that 30 days and can't file a complaint. You can't file the complaint anyway because you have to wait 30 days after you send the hardship repayment notice. Okay. If you've previously sent the hardship repayment notice and are now filing for diversion 30 days later or whenever later, you have to wait 30 days after you file for diversion, provided, here's the caveat, they give you a hearing for the diversionary program within the 30 days. If they can't give you a hearing within the 30 days, we can file for court right away.
So this is the good news, guys. This is what's happening right now. Okay, we have a number of cases, and Amanda can comment on just about how many, where we're filing for the diversionary program and we are not getting a date within those 30 days. So we are able to file for the eviction, which is fabulous news. Now you're still going to have to go to the diversionary program, but the good news is we now have teeth. We have a court date. Can't get any better than that, given the circumstances.
Okay, now I just want to let you know that the diversionary amendments have not yet passed City Council. So they're not in effect yet. Once they become in effect, it's going to be retroactive. The committee voted the bill out of committee. It went to the first reading last Thursday. It's going to go to its second reading this Thursday. It will most likely pass this Thursday since it's already passed out of committee and it's already passed through its first reading. After it passes this Thursday, the mayor has indicated that he will be signing the bill. So we've said things before in the past that we thought was pretty certain to happen and didn't. Caveat, nobody ever knows. So it could be that what we're telling you is not going to be the law with regard to the diversionary program, but we'd be really surprised if that didn't happen.
All right, we have a couple questions. Paul, can I ask these?
Sure, absolutely.
In the meantime, if someone comes up for non-renewal and they owe us money, can we do the non-renewal? Yes. Yep, this is for non-payment of rent. If you have a breach case or non-renewal, that's not what the hardship repayment stuff applies to. However, if you want to file for both the money and the non-renewal, then you're going to have to go this route. Okay.
The court has actually made this very confusing in Philadelphia, because you would think that if you had termination of the term, you would be able to just go ahead and file for that. But the court is saying, no, you still have to go through the rest of it if you're asking for the money that's owed.
Right.
So if you want to waive the money and just ask for termination of the term, we can do that. If not, then you have to go through the process that I just explained.
Okay. I filed for the eviction diversion program for a tenant, and I have a judgment on them already and never heard back from them. If you already have a judgment, you don't have to go that route. I mean, the lockouts are stayed for right now till next year, but once that's lifted, you should be able to file the writ and the alias writ of possession and then go forward with the lockout if you already have a judgment. If you wanted to get additional monies, then yes, you have to go through the diversion program. If you do not hear back from them within 30 days, you can go ahead and file your new complaint. I hope that makes sense.
Yeah, and as Janelle was saying, right now, all evictions are stayed through January. With the way the COVID cases are going and the spiking that we're seeing, the odds are, and again, I don't have a crystal ball and I'm hesitant to predict things, but it looks like that's going to get extended again. So you're still not going to be able to do the actual lockout. So if you're concerned about getting the additional money, you can file for the additional money so that you get it. You may want to do that right away, so you get a hearing date sooner rather than later for the additional money that's owed.
Jamie's asking, are we submitting every person who owes rent and received a hardship notice to the diversion program, regardless of whether they advise us of a COVID-related issue? Yes. The presumption at this point needs to be that if they're not paying rent, they have a COVID-related issue. So yes, in order for you to get into court for non-payment of rent at this point, you need to file with the diversion program. And then our suggestion is if we don't hear back from them within 30 days and we don't get that date within 30 days, we need to immediately file for that court date. I know it's kind of a little redundant because you still have to go to the diversion program. However, at that point, if they don't show up for the diversion program or you can't work it out of the diversionary program, then we can go to court. We'll have a court date. And given how far out they are, we want to file now if they don't give us a date within 30 days so that we can get the quickest date possible for that court date. Because then even if you go to the diversionary program and you work out an agreement and they default on the agreement, we still have a court date. We don't have to give up that court date. And now, boom, we're right in court rather than having to file. Because like Paul said, those dates are going to get pushed back further and further and further come January. So the faster we can get in court, the better. So you want to do these steps as fast as possible. So over time, you're going to hear from our girls. You're going to hear from Amanda and April saying, hey, the diversionary program, we were unable to get a date within 30 days. Do you want us to file in court? Your answer should be yes. It would be silly not to, or else you can hedge your bets, but you're looking at a court date way down the road if you wait. Okay. All right. Yeah, Paul.
The definition of a financial hardship under the new diversion bill, which most likely is going to get passed on Thursday and signed by the mayor, has been expanded. It's been expanded to include someone that has filed a declaration under the CDC order, which is a separate topic, the whole CDC guideline and the moratorium. That we have a separate seminar that we've done for that, so you can go ahead and look at that. But if they file that declaration, that's going to be included in the definition of a
I
financial.
have no volume on this stupid thing.
All right, I muted that.
On your computer, you should have a volume button that you can turn up the volume so that you can hear. Or I suggest using headphones is very helpful as well for these types of seminars.
Okay, a couple more questions, Paul.
Yes.
Actually, a lot more. If someone was on a non-renewal and refuses to leave, can we file for breach? Yes, you can file for both non-renewal, termination of the lease term, as Paul was saying, plus breach of lease conditions for them being a holdover tenant. You do not need to go through these programs to do that as long as you do not want to seek any monies, as Paul was saying earlier. All right. So if we do a non-renewal, are we forfeiting the money if we don't do the hardship offer first? Yes. If you want to seek monies, you have to send out the hardship repayment notice and you have to go through the diversionary program. Okay. Can we offer the hardship notice and payment plan after they've moved out? Once they've moved out, you're not in this program anymore. So you can go ahead and set up payment arrangements on any monies that are due in your like collection efforts, so to speak, after the fact. All right. Hope that makes sense. If it doesn't, reach out to me later. Okay, that's it. That's the last question.
Okay, I think that's it for the amendments to the Emergency Housing Protection Act. If anyone has any other questions or thinks of stuff, just put it in the chat and we'll come back to it. Next thing I want to talk about is the bed bug law. In December of 2019, pre-COVID, which everything was different back then, the
PC 19.
the city passed a bed bug law. The law is set to go into effect on January the 1st of 2021. This law sort of got lost in the shuffle here with COVID-19. Everything is happening with all the moratoriums, all the rest of the laws, lead paint, which we'll get to in a minute, and everything else that's happening. But this is going into effect on January the 1st, so you need to know about it. Very, very important that you follow the bed bug guidelines, because if you do not, you cannot collect the rent. So on new move-ins, before a tenant moves in, you have to give them a disclosure notifying them of what the bed bug law consists of and what their rights are. The problem is that that disclosure has to be on a form that is written by the city of Philadelphia. And as you can imagine, the city of Philadelphia has not yet written the form.
It's December 8th. You have to give this out by next month, and we don't have it yet.
So I've been asking them, actually reminded them that there is a bed bug law that's going into effect. Where's the form? And I think they are in panic mode trying to figure out exactly what that's going to look like. The problem for you is that you are already signing leases that are starting in January. You're signing leases that are starting in February, March, what have you, okay? All those leases need to have that disclosure in the lease.
Paul, I know I asked you this before, but for the whole class, does that apply to renewals?
No.
So just new leases, guys.
However, having said that, we have to see what the guidelines are that the city comes out with. So in the regulations, they may come out and say it does apply to renewals. But for right now, it does not. It's just new leases. So as part of that disclosure, and this is the killer part of it, you have to disclose whether or not you've had bed bugs in that unit over the last 120 days. Big problem. We fought that. They wanted it for a year. We got it to 120 days, moral victory. But it's awful, but that's what it is. Okay. You may want to start disclosing that now for new leases. You may not, because you may not be able to rent the unit, and you may want to wait till the actual disclosure forms come out. It's a business decision. But
Part of the problem right now is I know a lot of you guys are entering to leases now for next month. So what you're going to have to do once that form comes out is have them sign off on that after you have them sign their lease agreements. Because my guess is you have people signing lease agreements for next month already. So, and before you hand over the keys, you're going to have them sign off on this form. As soon as we have this form, Amanda will send out an email blast to everybody with the form or the link to the city where the form is, whatever it is. We'll let you know.
yeah, we'll basically do it as an addendum to the lease agreement. I've already notified NAA about this. So for those of you that use the NAA lease, they're ready to go to put the form into NAA, into the NAA leases, but obviously we don't have the form yet, so we can't do it. I was going to write the form, but unfortunately it has to come from the city. So I could write the form. It may not be valid as far as the city is concerned. So we want to make sure we have the right form that's included in the NAA lease and that you guys are going to use. So
Okay, two questions.
it's coming in the next week or so, hopefully.
Two questions. One, we do not have annual renewals. Tenants just stay and pay. How should we proceed? Nancy, stay tuned. We don't know. We don't even know if it applies to renewals yet. So we'll give you that information as we get it. And then Courtney asked, does that mean we can't allow someone to move in until the form is given to us? No. I think you'll have it before move-ins next month. Paul's pushing on it. But if you don't, we're not going to make you hold up your move-ins. That's crazy.
If the city doesn't come out with the form by the end of December, then I will have a form for you to use to give to your tenants. So at least you have something. All right. Okay, that's the bed bug law. And just as part of that law, just so you know, for the first year, you're going to be responsible for taking care of any bed bug problem that exists. After the first year, the costs of whatever the problem is are shared between the landlord and the tenant. Nobody knows what the definition of shared means. That's the actual word that they use. It doesn't say split. It doesn't say evenly divided. It says the cost shall be shared. We're assuming that means split, but who knows? We'll have to wait and see what the courts decide as far as that goes. I can see a situation where it's a cost that should be borne more by the landlord because the landlord could have caused the problem or came from a neighboring unit or what have you. And I can see a situation where the tenant brought the bed bugs into the unit, and maybe shared means that one party or the other should pay more of the cost. Stay tuned on that one. We don't know. That's it for bed bugs, unless any questions.
No questions on bed bugs that I haven't already asked. So that's good.
Awesome.
Cruising today.
Lead paint law. So we've already done a seminar on that. I just want to make sure that you guys are complying with the lead paint law. Went into effect as of October the 1st. It rolls out based on different zip codes. I think 10 or 11 zip codes went online as of October the 1st. More come into compliance as of April 1st of 2021. Then more as of October 1st of 2021, and the rest of April the 1st of 2022. Some of you may have noticed, and some of you pointed out to me, that on the NAA lease, there was a mistake with regard to that 2022 date. It's actually said 2021. NAA has subsequently fixed that. So NAA does have the updated lease form. NAA does apologize in not being able to get the form out quicker. The problem was that the way I wrote the addendum, there are a lot of fill in the blanks, and whenever they have fill in the blanks programming wise, for those of you who know programming, computer programming, it's a lot more complicated to write the code for fill in the blanks. It's not just straight type. So because there were so many fill in the blanks on the form, it took them a lot longer to get that all completed. But it is done, and it is up and running. We also have copies of it if anybody needs it. That should be attached to all your lease agreements. It's for all your leases, and this does apply as well to lease renewals. Okay, very, very, very important that you comply with the lead paint law. If you do not, go ahead.
No, I was just going to say, there is a link on our website. The last seminar we did with regard to Philadelphia is on our website. It goes into great detail about what the new lead paint law is, what you need to do, and how it differs from the last law. We probably spent a good 20 minutes talking about it. So please, please, please go check that if you have any questions. And if that doesn't clear it up, reach out to Paul or myself, okay?
Yeah, and why it is so important is not only can't you collect the rent if you don't comply with the law, any rent that you've already collected while you were not in compliance with the law, the tenant is entitled to sue you to get that money back. And attorneys are doing that. There's now a cottage industry of attorneys that have sprung up that are suing just on these types of cases. So it is crucial that you comply with the lead paint law. So all these things we're telling you that if you don't comply with, what ends up happening is you're not able to collect the rent. What makes the lead paint law even more onerous is that they can sue you for the back rent that they've already paid you. So make sure that you're complying with it.
Yeah.
I just did want to mention, next topic I see is update on the diversion program. I just did forget to tell you that with the diversion program, it was until the end of December that you had to comply with the diversion program. That's been extended an additional 3 months to the end of March. So that now runs through March the 31st.
31st. And I wouldn't be surprised if you see that go longer into the summer. I think it's going to be here for a little while. Someone did have a bed bug question. They jumped on here. Do the tenants have to disclose if they had bed bugs?
The tenants do not. However, the NAA lease, and I suggest you put it in your lease as well, requires that they disclose that information. They should be disclosing that on your rental application, actually, before they even sign the lease agreement, so that you know whether or not they're coming from a property with bed bugs.
Yeah, you can ask them that, but there's nothing in the law that forces them to do it. And yeah.
If the tenants violate the law, this is great. Not great, it's actually terrible. But the remedy for the landlord is you can evict them. You get no money.
Hey!
You get to evict them, that's great.
In 9 months when we get in court.
Right now, exactly. Okay, I did want to touch on the security deposit law. I was going to talk more about that, but fortunately that bill was pulled. It looks like it may come back in January. We fully expected that to get passed, but fortunately we were able to help to get that bill delayed. So that's good news. What is the security deposit law, the new law? Basically says, you're going to love this one if you don't know it already, that the tenant can pay the security deposit over a 4-month period. So they no longer would have to pay the security deposit up front. They can pay it out over 4 months. The original bill also required that you had to accept security deposit insurance. That was taken out of the bill, but the rest of it still exists. The bill was introduced. It is proceeding, but like I said, the hearing on it has been delayed, so it hasn't been voted out of committee yet. I fully expect that that bill will be moving forward in January, and there's a good likelihood that that will get passed. All right, I think that gets you guys up to date. I think the only other things that are going on real quick, City of Philadelphia, 1% construction tax, that's most likely going to get passed in some form. Tax abatement, that might get delayed. The resident, so when I say delayed, so let me just go back a second, I'm getting ahead of myself. The tax abatement, the 10-year tax abatement, it's scheduled as of January the 1st to start being scaled back. So that's on residential construction. If you have residential construction right now, you get a 10-year tax abatement. That tax abatement is now going to be rolled back to where you get 90%, then 80%, and 70%, et cetera. 10% gets cut off every year until it goes to 0. That's supposed to take effect as of January the 1st. There's a bill to move that back. Hopefully that'll get moved back for a year. It might be 3 months. We're not really sure exactly what that time period is going to be. Good likelihood that that's going to get passed on Thursday as well. So stay tuned for that one. And I think, there's a moratorium on restaurant evictions for those of you that have restaurants. Not going to go into the details of that right now. We'll see if that gets finalized. We're just waiting for the mayor to sign it. He most likely is going to do that. So that's past city council. But that basically stops you from being able to evict anyone that has a restaurant with less than 100 employees, and there's less than, I think if they have less than like 3 restaurants of the same name, something like that, you won't be able to evict those restaurants.
What does that run through, Paul? Do you know?
180 days. So it's 180 days from the date that the law gets enacted. It hasn't been enacted yet. The mayor hasn't signed it. So stay tuned on that one. If you guys own any, not own, if you have, well, if you own.
If you know the building where a restaurant is.
And I think that's it. Do you have any other questions? I think good. 35 minutes.
Very good. No more questions, but I do want to comment. Some of you may have gotten an email already. We can only send so many a day. So if you haven't already gotten it, you'll get it today or tomorrow. We are doing an end of the year wrap up for every jurisdiction that we cover. Marley can jump on and tell you the date. I think it's a Wednesday. I think it's in 2 weeks. 2 weeks, Marley?
Next Wednesday, December 16th at 10 a.m.
There you go. December 16th at 10 a.m. We're going to do a wrap up on Pennsylvania and Philadelphia. I keep them separate because Philadelphia is its own world, let alone its own city. New Jersey and Delaware. So between Paul, myself, and Matt Bradley, we are going to give you an update on where things are as of mid-December 2020 and what you can expect looking forward in 2021. It'll be a little bit longer. We're probably going to do Philadelphia at the end because there's just so much more involved with Philadelphia. So we'll do that. We'll get through each jurisdiction. You can jump on and off as you need to, and we'll put that on our website as well. But jump onto that seminar if you can, try and recap everything and tell you what's on the horizon.
And we'll go through all the changes that occurred between now and then.
Yeah, that too.
All right.
All right, guys. Thank you so much. Have an awesome Tuesday, and we'll see you next week. Bye, guys.